Assalamualaikum and hello. My name is Nurul Adini binti Abdul Razak with the number matrix of 244216, and I'll be explaining regarding the second part of the fact of the case.
Hi, my name is Nuha Ivana binti Mak Shukri, matric number 264467. I will present the part of Principle of Law.
Assalamualaikum and good day. My name is Nur Shahidatul binti Ahmad Zaini, matric number 264617. In this group project, I will be presenting on the first part of facts of the case.
Assalamualaikum and good day. My name is Nur Katiha Asmida, matric number 264716. I will present on the principle of law.
Good day everyone, my name is Ho Yong-yi, matric number 264717. I'm going to present the head of the case and compiling the video. So let's start now.
Facts of the case. This is an appeal case whereby the appellant was a company registered under the Companies Act 1965 and the respondent was a cooperative society registered under Cooperative Societies Act 1948. The appellant had executed a charge over its land as security for a loan given to one of its directors by the respondent. The loan was not for the benefit of the said director, but for the purposes of the appellant. Subsequent to this, the appellant later applied for a declaration that the said charge is null and void by virtue of Section 133 of the Companies Act 1965 and a consequential order to cancel the charge registration.
The issue which arose eventually for the decision was whether the provision of the National Land Code 1965 operated to invalidate the charge. It was argued by the appellant that the prohibition imposed under Section 133 regarding on the security by the company in connection with a loan made to its director had made the charge as unfit for registration and void. However, the court was in the opinion of that the charge was valid and enforceable, hence this appeal application made by the appellant.
The appeal was allowed by the court to declare the charge as invalid and order it to be cancelled. As of the facts, the loan was not for the benefit of the director, but for the purpose of the appellant, which refers to the company. Due to this, it does not exempt the appellant from the prohibition against the provision of security as contained in Section 133 Clause 1 of the Companies Act 1965. So, the prohibition against the appellant on providing the security is still applicable. Therefore, the charge was void and unfit for registration.
In the case of Harta Empat Sendirian Berhad against Koperasi Rakyat Berhad, the main provision referred was Section 133 subsection 1 of Companies Act 1965, where it concerns the loans to directors. The respondent, who was a cooperative society, appeared to be the appellant's choice as a place to borrow money, and this action was taken since Section 30 of Cooperative Societies Act 1948 has stated that the members of the society could borrow the money from the respondents. However, the appellant unable to do so on its own except for using their director as the device to borrow the money, since Section 21 subsection 1 of the Cooperative Societies Act 1948 has already provided that the appellant's membership of the society could not be qualified because the condition must be a natural person and not a company. Hence, the director was a chosen qualified person to make a loan from the cooperative society after applying for the membership as under Section 21 subsection 1 of Cooperative Societies Act 1948, although the appellant should not have done that just to get the money as they wished to. On top of that, the respondent was not absolved from Section 133, Subsection 1, Subsection A of Companies Act 1965 just because the loan made by the director for the benefit of the company, that is the appellant. This is because of the desired effect of prohibiting the appellant from giving any security to the director for the loan made to the respondent was held under the Section 133, Subsection 1, Subsection A.
Although there was an exception to this prohibition, whereby the act of providing loan, security and guarantee by the company to the director can be done only if it was done to provide such a director with funds to meet expenditure incurred or to be incurred by him for the purpose of the company, but still, in this present case, the funds were not intended to cover the director expenses, so the prohibition against the appellant offering protection remained in fact. In addition, an instrument on land is only fit for registration only if the condition laid down under Section 301 of the National Land Code 1965. Subsection C focus on the situation where the dealing must not contradict to prohibition or limitation provided in the code itself as well as any written law in the nation. Thus, the constraint in Section 133 Clause 1 of the Act was interrelated with the unfit registration under Section 301 of the Code, which it could not be done as usual or as it would appear ultra-virus. Due to this intertwined situation, the court has decided that the appeal was allowed, whereby a declaration to declare the charge invalid was granted. This came together with the order to cancel the charge, and due to that, the cause here and in the court below should belong to the appellant. In conclusion, upon appealing, it was established that Section 133 Clause 1 imposed a blanket prohibition on loans by a company to a director of the company and on the giving of a guarantee or the provision of security by the company in connection with a loan made to a director by another person, even though a contract has been entered into by a director with his or her company. This is intended to provide some protection for creditors and members from potential abuse by director of the control they have over the management of a company's affairs.